Okay, so she didn't watch it on live stream.
Okay.
And I don't know how she was in a breakout room and Mr. Murat talked to her or not, and then didn't bring her out. Now, the only thing that could have happened, okay, so let's go with something that is potentially what happened.
Buckle up, because this isn't your typical probation review. Today, we're stepping inside Judge Bryant's courtroom, where a simple case of early probation discharge takes a sharp turn into a heated truth check. On one side, we've got Miss Arnold, who's reportedly followed every term of her probation. On the other, a judge who's not about to let even the tiniest misrepresentation slide, intentional or not. We're about to see a defense attorney scrambling to explain why her client missed a crucial court date, and a judge laser-focused on the facts. And here's the kicker. This case goes from routine paperwork to a moment of pure legal drama when claims about live streams, breakout rooms, and courtroom procedure collide head-on. Who's telling the truth? Was it just a misunderstanding or a dangerous lapse in courtroom integrity? You're about to find out, and trust me, Judge Bryant doesn't play.
For an arraignment on a bench warrant. Appearances, please.
Record, Your Honor. Christina Ritter on behalf of the people.
She's on probation. Miss Stevenson.
Janice Stevenson appearing on behalf of Camry Arnold. Ms. Arnold, ma'am, please unmute and say your first, middle, and last names.
Camry Amanda Arnold.
All right, today is a day set for review. And wait a minute, what? Hold on. I don't know why I got this. Wait a minute. All right, today is a day set for an arraignment on a bench warrant. Miss Stevenson asked to the arraignment on the bench warrant.
Waives the reading of the information. Asked that a plea of not guilty be entered on her behalf. And I'm asking that we proceed to review, Your Honor.
Court will set aside any warrant recalling any capias and proceed immediately to review.
Thank you, Your Honor.
Right out of the gate, the defense is making the strongest pitch possible, early discharge. They claim Miss Arnold has not only followed all her probation requirements, but she's already passed the halfway mark. In most courtrooms, that's the green light for early termination. But here's where it gets tricky. There's a lingering issue, her absence from a scheduled court review. And in Judge Bryant's court, you don't just gloss over a missed date without ironclad reasoning. This moment is key, because if the explanation doesn't add up, the judge could easily decide that early discharge isn't happening today.
It is my understanding that Ms. Arnold has complied with all the terms and conditions of probation.
You did something. You went out.
Thank you, Your Honor. I'm assist still. It's my understanding that Ms. Arnold has complied with all the terms and conditions of the probation, and she's passed the halfway mark. I would move that this matter be closed with improvement at this time.
Can you tell me why she missed her review on May 1st?
Your Honor, Ms. Arnold advised me that she did have an interview in a breakout room. I've been able to surmise, I think that was with Attorney Murat. She's indicated that she waited in the breakout room and then came out to the main session and was not admitted. She sat there until she was the meeting was closed. She's indicated to me she did check in or started viewing the proceedings on YouTube, did not understand what happened. I don't have an explanation as to why she was not admitted into a meeting.
She didn't view no proceedings on YouTube on May 1st.
I don't think it was May 1st, but
it was May 1st.
Okay.
Well, let me say this. Let me apologize. Let me double back. According to the review that Ms. Tucker sent, her date was scheduled for May 1st. So according to the review that Ms. Tucker sent. So Mr. Flanagan, when was she supposed to be here?
May 1st, Your Honor.
Okay. So Ms. Stevenson, tell me um, what proceedings was live streamed on May 1st?
I don't have an answer for that, Your Honor. I was reading the report. My representation is based upon the report that I thought the review hearing was April.
Well, she didn't watch nothing on live stream on May 1st because
this is the turning point. Judge Bryant just dismantled the live stream excuse with surgical precision. The judge makes it crystal clear. These proceedings haven't been live streamed for ages, so Miss Arnold's claim that she tuned in online simply doesn't hold water. In legal terms, this is a credibility hit, and it's significant. Even if it's just a misunderstanding, the court now has to question how information is being communicated between client and attorney. And if you've ever wondered why judges drill down into the smallest details, this is why accuracy is everything in court.
Okay.
All right. Okay, so I don't know because I didn't speak with Ms. Arnold at her last court date, Your Honor. I don't know why she was not present. I was just relating to the court what Ms. Arnold told me, and I think Ms. Arnold hears that whatever her explanation is not satisfactory.
Let me interrupt you. You might be relaying what she said, but let me tell you what you know.
Yes.
So let's not just come on the record relaying what my client said if I know that what my client says is not true. What you know about Judge Bryant is that until yesterday, and now today, I have not live streamed my Zoom proceedings in ages. So when your client says, I went off and watched it on the live stream, then you supposed to say to them, are you sure? Because Judge Bryant don't live stream. Now, if somebody comes and say they watched live stream yesterday, and then somebody comes and says they watched live stream today, the 2 days that I'm live streaming, then we can say, oh, yeah, she did live stream after Tommy V died. But you can't just relay on the record something your client says that we know not to be true.
Judge Bryant is laying down a firm line here. In her courtroom, defendants don't get ignored. If you're on the docket, you will be addressed. This is as much about protecting the court's integrity as it is about protecting the defendant's rights. What she's subtly saying is, if Miss Arnold was indeed in the breakout room and something went wrong, it's far more likely a miscommunication than a systemic failure. This is the judge reclaiming control of the narrative and making sure no one walks away thinking her courtroom is careless.
Okay, so she didn't watch it on live stream. And I don't know how she was in a breakout room and Mr. Murat talked to her or not, and then didn't bring her out. Now, the only thing that could have happened, okay, so let's go with something that is potentially what happened. What potentially happened was that Ms. Arnold appeared for court, was interviewed by one of your colleagues, was in the breakout room, and then the court got busy with its trial docket and relayed to Mr. Murat to tell his client that they were going to have to get a new date. And so apparently, perhaps that didn't happen. But what didn't happen is that she came in my courtroom and sat all day and nobody acknowledged her, because that wouldn't happen in my courtroom.
Okay. Can I also say what didn't happen, Judge? I did not, I never have, and I never would relay information to this court, whether somebody said it to me or not, that I know to be untrue. I didn't do that. I never have, and I never will. I would apologize to this court for not doing a better job of doing an investigation as to whether or not we were live streaming on May 1st. That I never have, and I'm never going to come to this court and make a misrepresentation to say anything that I know to be false, Judge. I've never done that, and I'm never going to. I'm sorry. I should have checked to make sure. But I did not do that. I would advise the court that the information that I got from my client was something that she did not understand. So I would, apologize for not being clear about that. But I don't come to this court just saying stuff.
And just like that, the defense pivots hard back to the win they came for, early discharge. It's a smart move because by reaffirming that all probation conditions were met, the attorney is pulling focus away from the live stream dispute and back to the core point, her client's compliance. This is a common tactic in court: acknowledge the hiccup, then redirect to the strongest legal argument you have. The question now is, will Judge Bryant let that live stream story slide as a harmless mix-up, or will it stick in her mind as a red flag?
That I know not to be true. I didn't do that, Judge. I never would. But Ms. Arnold, to my understanding, has complied with all the conditions of the court's order, and she's done it within the 12 months, Your Honor. So I believe she's eligible for early discharge from probation, and I would so move at this time.
And I agree with you. According to Ms. Tucker, Ms. Arnold completed the terms and conditions of her probation. She was placed on a 12-month probationary period, October the 20th, for 12 months, which would bring us to past the halfway point in October. And she was probably past the halfway point. Really, her halfway point would have been in May. And so, would have been in May. And according to Ms. Tucker, or despite the representation that she failed to appear in May, why does this say? Hold on. Okay. The court is going to
decision time, and Judge Bryant is going with a full early discharge. Despite the May 1st absence and the questionable live stream claim, the judge is focusing on the big picture. Miss Arnold met the conditions, stayed on track, and hit the halfway mark. It's a reminder that while courtroom drama can get intense, judges ultimately have to balance procedural issues against overall compliance. Here, the scale tipped toward leniency. For Miss Arnold, this is the best possible outcome: a clean break from probation and the chance to move forward without court oversight.
Prior to being placed in one. Okay. The court is going to discharge Miss Arnold from probation with improvement and close the matter out. Was the matter no, it's the OWBI. And close the matter out as she has successfully completed at least half of her probationary period. And she has finished the terms and conditions of the probation. Ms. Arnold, we will mail you a copy of the order of dismissal. Sorry, not dismissal. The order of discharge for your records, ma'am. Have a great day and stay safe.
And that's the case. Miss Arnold walks away with her probation discharged early, despite a brief storm over missed hearings and live stream confusion. This hearing shows us two things. First, that clarity and honesty between client and attorney are non-negotiable, and second, that compliance with court orders still carries serious weight, even when small procedural hiccups happen. Judge Bryant maintained control, dug into inconsistencies, and still delivered a fair result. What do you think? Was the judge too lenient here, or was this the right call? Drop your thoughts in the comments, hit that like button if you found this breakdown insightful, and don't forget to subscribe so you don't miss our next deep dive into the most jaw-dropping moments from inside America's courtrooms.